Honorable Justice Angelina Sandoval Gutierrez, Honorable Toribio E. Ilaw Jr., and Honorable Jose B. Mejia. Please remain standing for the centennial prayer for the courts, the national anthem, and the Supreme Court hymn.
Almighty God, we stand in your holy presence as our supreme judge. We humbly beseech you to bless and inspire us so that what we think, say, and do will be in accordance with your will. Enlighten our minds, strengthen our spirit, and fill our hearts with fraternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness for the fulfillment of your greater glory. Amen.
Bayang magiliw, perlas ng silanganan, alam ng puso, sa titik mo'y buhay. Lupang hinirang, duyan ka ng magiting, sa manlulupit, di ka pasisingil, sa dagat at bundok, sa simoy at sa langit mong baka, may nilang ang tula at awit sa paglayang kailangan. Ang kisap ng watawat mo'y tagumpay na nanginigil, ang bituin at araw niya kailan pang may magdidilim. Lupa ng araw ng warangit mong sinta, ay langit sa likod. Aming ligaya na pag may mamapit, ang namatay ng dahil sa'yo. Behold the guardians of our rights, enrobed in majesty and light, uphold the fundamental law. From his writ all their judgments flow. With conscience free their bills to bear, they vow and
public interview of applicants for the position of Justice Bienvenido Reyes, who will retire on July 6, is now open. So, Madam Clerk of Court, please introduce to the Council the names of the interviewees today.
Yes, Your Honors. Your Honors, the candidates to be interviewed this morning are Court Administrator Jose Maidas P. Marquez, Office of the Court Administrator, Supreme Court, Court of Appeals, Associate Justice Apolinario D. Bruselas, Court of Appeals, Associate Justice Rosemary D. Carandang, and Court of Appeals, Associate Justice Stephen C. Cruz. May I now request Court of Appeals, Associate Justice Bruselas Jr., Associate Justice Carandang, and Associate Justice Cruz to stay in the holding room while the interview of Court Administrator Marquez is being conducted. Thank you, Your Honors. May I now request Court Ad to occupy the hot seat. Court Ad Marquez, Your Honors.
So we'll now start the interview. First is Court Ad Maidas Marquez. May we request now Judge Ilaw to initiate or to start the interview?
All right, thank you, Madam Chair. Yes, good morning, Attorney Maidas.
Good morning, po.
Marquez. How are you today?
I'm fine, thank you, Your Honor.
So, you stated in your article published in the Business Mirror on October 8, 2015, that you do not aspire to become a justice of the Supreme Court. What changed?
If I'm not mistaken, Your Honor, that was when someone nominated me to become or someone sent me to become nominated me to become a justice. No? Back then, I thought that I did not have the necessary experience, even the wisdom to become a member of the Supreme Court. But because of my experience and what I've done after that, and also with the nominations of the judges and the court personnel, I thought that I should give it a try already, Your Honor.
Why do you want to become a Supreme Court justice now?
Your Honor, I've been a court administrator for 7 years. In fact, the longest court administrator already in the history of the Philippine Supreme Court. I've been with the Supreme Court for more than 2 decades, more than 25 years. I started as a law clerk. I worked for several justices of the Supreme Court as a law clerk. I became the project director of the first comprehensive technical assistance to the Philippine judiciary, which paved the way actually for all the development partners to partner with the Supreme Court eventually. World Bank, USAID, ADB, COICA, SIDA. No. I've authored a number of law books. I've spoken and defended the Supreme Court, spoken for and defended the Supreme Court in extraordinary times. As court administrator, I have dealt with judges who are 20 years, 25 years my senior. I've dealt with media. I've appeared in congressional hearings. And I think those experiences are enough for me to merit a position in the Supreme Court.
Do you believe that such route you choose to get to this is the best?
Your Honors, I would like to think that I've been trained under some of the finest justices of the Supreme Court. I may not have been a judge. I may not have been in private practice.
May not been a justice in the Court of Appeals?
Yes, Your Honor. But I think that is the essence of a collegial court like the Supreme Court, where the members come from different perspectives, no? So that they can give their own perspective when they come to deliberations of certain cases.
Sir, who do you look up to in the Supreme Court? Who do you look up in the Supreme Court? Who is your role model?
The present Supreme Court, Your Honor?
Yes, please.
Well, I think the justices, all the justices, have their respective strengths. So for certain expertise, then I look up to certain justices, Your Honor.
What practices of the Supreme Court justices will you enumerate? And what are those that you want?
Well, I think
About our colleague here, Justice Gutierrez. There.
well, with all due respect to Justice Gutierrez, I was a law clerk when Justice Gutierrez was an incumbent member of the Supreme Court. We were also together in the UNDP project. That was the first comprehensive technical assistance to the Philippine judiciary. And, of course,
Court, why don't you mention first Justice Herrera?
well, Justice, I've worked for a number of justices, as I've said earlier. No, I started with Justice Sarmiento, Abraham Sarmiento. Justice Abraham Sarmiento is a free-thinking liberal, so I was trained to think also like him, and then I joined the office of Justice Amorfina Melencio Herrera, who was a very strict conservative. So they were, I would consider, poles apart. And then my third justice is, of course, Justice Bellosillo, who I'd like
Who is
to...
present here?
Yes,
Yes, Your
Good
Honor.
morning, Justice.
What can you say about justice? At any rate, as court administrator for 7 years, Tony Marquez, what are the concrete results of your hard work for the interest and welfare of the judges and court personnel?
Your Honor, I always, when I applied for court administrator, I took it upon myself to really work for the welfare of the judges and court personnel. They are first and foremost I considered my constituents, and so I always try to hear them, listen to them, and do what I think is best for the institution and for the judges and court personnel. We have a number of reform measures that we have done for our lower courts, except that I think there's still a lot to be done because our resources are very limited. Right now we have more than 2,700 judicial posts for the lower courts. We have more than 30,000 court personnel, but our structure has not changed since I occupied the position of court administrator in 2010. Our budget has remained the same. I've always been thinking or pushing for automation, but we have very limited resources. Right now, we are prioritizing the automation of the lower courts. So hopefully, once we are able to complete the automation of the lower courts, the Office of the Court Administrator will follow.
All right, what is the rate of the discipline given or undertaken by your office with respect to alleged erring judges and justices?
Your Honor,
Being this, yours truly had been a retired RTC judge, I've seen and learned that there have been turtle pace or slow pace in resolving administrative cases against judges in the field?
Your Honor, our mandate as in the Office of the Court Administrator is purely recommendatory. Even administrative cases which we think should be denied or dismissed outright because they are either judicial in nature or there is no merit at all, we have to submit this recommendation to the court, and it is the court which eventually resolves these cases. My view, or what I've done, is that whenever I see a complaint that is not meritorious, I already almost always I already submit the recommendation to the court even without requiring the judge or the respondent to comment. On the other extent, if I think that there is really an erring judge, and it is brought to our attention on a mere anonymous complaint, which is not, of course, sworn to and subscribed, we looked into it. We look into it right away. We conduct a discrete investigation, and after we get the desired results, we require the judge to comment, and that is already the start of a formal investigation against the respondent.
So what is your competitive edge over other applicants who are Court of Appeals justices and have many years of experience in disposing cases and had litigation experiences?
Your Honor, I think my background is very varied because I've headed the reform initiatives of the court. I have been a spokesman of the court for around 5 years, defending the court. I have appeared in congressional investigations for the court. Quite recently, I was invited by the House of Representatives as a resource person when they were discussing the martial law issue. I have also been involved in many rulemaking powers of the court, the writ of amparo, the writ of habeas data, writ of kalikasan, small claims procedure, continuous trial, practice guidelines. And I think my 7 years experience as a court administrator is something that my co-applicants do not have.
All right, thank you. My time is up, and thank you for your time, and good luck to your journey.
Thank you, Your Honor.
Thank you, Judge Ilaw. May we now request Attorney Mejia to continue?
Thank you, Madam Chair. Good morning, Attorney Marquez.
Good morning, Your Honor.
For starters, let me refer or let me make a reference to the letter of Judge Georgina Hidalgo in her endorsement on behalf of the Philippine Judges Association, where she mentioned that we firmly believe that that he, referring to you, is the best man for the job and will definitely be a great asset to the judiciary. Why is that so?
Well, I think they have seen what I've done, my character as a court administrator for the last 7 years. And that is why the Philippine Judges Association, through Judge Hidalgo, came up with that resolution. No? And also, actually, that was, if I may mention, that was followed by a letter of endorsement by the PASE, or the Philippine Association of Court Employees. This is the umbrella organization of more than almost 30,000 court employees. And later by resolutions from METSIJAP and the PTJL, the two judges organizations of the first level courts, which I consider the highest form of compliment coming from for a court administrator, because the court, the judges and the court personnel are the constituents of a court administrator, and they stand to benefit or suffer either benefit or suffer from the actions or inactions of the court administrator. So receiving those compliments, I think, is really the highest form of compliment a court administrator can have.
What are your thoughts on federalism?
Federalism, I think, is an option. We've had constitutional democracy for the longest time, and federalism can be an option. No? With regard to courts, in a federal form of government, we will have different state courts and federal courts. And my understanding is that in the different states, it will be the courts will be created by the different states. They will have their own maybe court administrator, and therefore because it is smaller in scale, then it can be better managed and run. No? Also, the appointments are being done most probably by the governor or the heads of state of the different states, and therefore the appointing authority will have more chances of knowing personally, no, the judges to be appointed, as opposed to what we have right now, because the president, more often than not, would not know who the judge in, let's say, Abra he is appointing, no? Or the judge in Cagayan, because he comes from the south. No? But in a federal form of government where you have state courts, and it's the governor, the head of the state, who appoints, then most probably he will have a good fair of knowledge of knowing who the judges to appoint. Now, for the federal judges, because that will be much lesser, no, than the number of judges we have now, then the president, no, if he will still be the appointing authority for the federal judges, will have more chances, no, of trying to know who these judges will be.
Attorney Marquez, you once sat as a consultant of the Judicial and Bar Council. Given the chance and having observed the process, what improvement, if any, do you have in mind to improve the vetting process of judges and justices in the judiciary?
Your Honor, with all due respect, I think the vetting process is going on very well. The only perhaps area where with the Judicial and Bar Council can improve, and again, this is with all due respect, I know it's a very difficult job because there are so many applicants in some areas and there are so few applicants in other areas. But sometimes it takes some time, no, before the shortlist or before some judges or some applicants are considered for some vacant posts, especially if that particular branch has is an overburdened court, no? Because as I understand, Your Honors, the JBC does it per region. You go for region 1, 2, 3, 4. The problem that I've seen or observed is that after you've, let's say, finished region 11 or 12, and then you go back to region 1, and then there's a vacancy in region 10, which needs urgent attention, it will take some time before that vacancy is again considered.
Okay, that's
Again, Your Honor, that's with all due respect.
Of course, that's noted, and thank you. May I now give an opportunity to those who tweeted questions, and please answer these particular questions briefly and succinctly, if I may suggest. What are your thoughts on the following key issues? No? Number 1, martial law declaration. Number 2, Enrique bail. And number 3, Enrile bail, I'm sorry. And number 3, Marcos burial.
Number 1, martial law declaration. The Constitution is very clear, Section 18 of Article 7, I think. It's very clear when the President can declare martial law. It's very clear also that the Supreme Court can look into the the reasons for the declaration. It's now pending with the court. We've heard arguments last week, and I think this is a fair issue for the court to consider. With regard the Enrile bail, well, the court has already spoken. The former Senate President was granted bail for humanitarian considerations. We also have to consider, I think, as what the court did, his advanced age. So again, the bail is rest upon the sound discretion of the court, considering all the factors.
Maybe the question of the tweeter is he wants your opinion on whether or not you agree to that particular decision.
Well, I've read the decision on the former Senate President, and I think it was a sound decision because the court considered so many factors, no, in that particular case. As I've said, the advanced age of the former Senate President, and also his medical condition at that time. No? So, and when we say bail, we also think of a flight risk. No? I don't think the former Senate President is at all a flight risk. So I think the Marcos burial also was a hot issue debated not only in the court but also by the general public. The court has spoken. I've read the arguments, no? And the reasons, the justifications, the rationale, no, of the decision, and I think it is a sound decision. I think that issues like that really have to rest already.
Okay, that's my final question. Good luck, Attorney Marquez, and thank you, Madam Chair.
Maraming salamat po.
Thank you so much, Attorney Mejia. Good morning again, Court Ad Marquez.
Good morning, Your Honor.
So, of course, you know that under the JBC rules, as amended, one of the requirements to determine whether or not the candidate or applicant is really qualified is to test his or her mastery of rules, constitution, special laws, and jurisprudence. Okay, let us see first question under the Constitution. What do you mean by the establishment clause of the Constitution?
I think, Your Honor, what is meant is if a certain policy, no, is established, and the courts will have to decide whether on a particular issue. Let's take, for example, Your Honor, the recent decision of the court wherein there was a complaint from an individual, no? Because there were daily masses being held in the Hall of Justice.
First of all, before you mention that case, what do you mean by the establishment clause? Can you cite the provision of the Constitution?
The establishment clause, Your Honor, to
No law shall be passed establishing.
Okay. No law shall be passed establishing a religion, certain.
No law should be passed respecting the establishment of a religion. Okay. So, question. A committee, of course, you have been here all along, has composed this prayer we are praying now. And it is mandatory for all the courts, especially from the highest to the lowest courts, that this should be prayed before every proceeding, every session. Do you think this is not a violation of this establishment clause?
I don't think.
As was the decision of the United States Supreme Court in Engel, E-N-G-E-L?
I don't think, Your Honor, because the prayer, if we're going to look at the prayer, is a multi-faith prayer. It is not a prayer of one single congregation or belief, and therefore it does not. No one single religion has advantage, no, over that particular prayer. So it is for everyone, no, that prayer, Muslims, Christians, Catholics, and the other congregations.
So it does not violate the Establishment Clause because the prayer involves the prayers of all religious sects.
It can be prayed by all the religious sects, Your Honor. That's why I don't think
And
it
the
established.
Establishment Clause specifies, mandates that the state should be neutral. It should not enhance religion. It should not prohibit religion. That is the Establishment Clause. Okay. Go to what is happening now to the Court of Appeals. Speaker Alvarez said that by passing a law, Congress can abolish the Court of Appeals, and then justices can be impeached. And right now, 180 members of the lower house have signed a petition for the disbarment of these 3 justices. What's your comment on that? Do you think Congress can abolish the Court of Appeals? That's the first question.
Your Honor.
What is the provision under the Constitution?
Your Honor, I think the provision there is Section 2 of Article 8, wherein the Constitution provides that no law shall be passed
In
reorganizing
the judiciary,
and whenever courts are reorganized, the security of tenure of the justices
The
shall
members.
be observed.
third, is there a present reorganization? By abolishing the Court of Appeals, is that a sort of reorganization of the judiciary?
Well, Your Honor, I don't think so, because it is not abolition alone is not reorganization. When you say reorganization, you look at an existing court, you try to see what are its weaknesses and what are its strengths, and then you abolish it, and then you create a new one, and then to have
So there is no reorganization at present, but the Constitution says in reorganizing the judiciary, there is no reorganization. The security of the members of the judiciary is really protected.
Yes, Your
So
Honor.
there is no reorganization. Do you think Congress can pass a law, considering there is no reorganization now, abolishing the Court of Appeals,
Well, I think, Your Honor,
especially BP 129 as amended?
well, Your Honor, I think it's premature to say that there is already abolition or even reorganization.
Question, you just answer yes or no.
I don't. No, Your Honor, I don't think so. Because that statement of abolishing the Court of Appeals cannot be considered reorganization.
Are those justices impeachable?
The Court of Appeals justices, Your Honor, are not impeachable. Only the justices of the Supreme Court, the President, Vice President.
Well, I'm just asking your opinion, no? Parang lang ito, academic discussion. Do you think the justices of the Court of Appeals acted correctly when it issued a writ of habeas corpus for those 6 officials punished or declared or cited in contempt by Congress be released from detention?
Your Honor, I think that case will have to be studied carefully. No?
No, on the basis of the newspaper's report, do you think they are illegally detained for refusing to answer the questions being propounded by Congress?
Well, Your Honor,
Or declared in contempt for disobedience?
well, Your Honor, I think this has to be studied carefully because Congress has its own rules. No? Of course, the courts are co-equal branches of government with the legislature. I think we have to be reminded. We have to be reminded by what Alexander Hamilton once said, that the judiciary is the least dangerous branch because, by comparison, it is the weakest branch of government because it has neither the power of the purse nor the sword, only decision. But
So you mean the Court of Appeals cannot interfere?
no, Your Honor. I'm not saying that, Your Honor, with all due respect. I think the Court of Appeals
the Court of Appeals can order the release.
Before I think the Court of Appeals orders the release of those held in detention inside Congress, I think the parties will first have to convince the Court of Appeals that the Court of Appeals has jurisdiction over that particular
It has
incident.
issued its writ.
Yes, Your Honor.
Mutin academic na.
Your Honor, I think the mere issuance of the writ does not already right away means that the Court of Appeals is already exercising jurisdiction. The issuance of the writ
The
only...
question is, are they illegally detained for refusing to answer? Just answer that question, yes or no, and then that's the end of my question.
Your Honor,
As far as the Congress is concerned, they are not what? Or they are?
I think as far as Congress is concerned, they were not answering the questions sufficiently.
No. As far as Congress is concerned, the detention is legal or illegal?
Well, I think, Your
If
Honor...
Congress considers it legal, there is ground to detain them. Are they illegally detained? So, question, you have your own opinion on that. Okay, a while ago you answered that you agree fully with the decision of the Supreme Court granting bail to Senator Enrile. I dissent. Why? Why do you agree?
Well, Your Honor, I think the Supreme Court took into consideration...
No, first, cite the constitutional provision. All accused are entitled to bail except those charged with capital offense when the evidence of guilt is strong. On the basis of that, do you still agree?
Well, Your Honor, I think that was also considered by the Supreme Court, but also the Supreme Court considered...
First of all, what was the motion filed by Enrile through his lawyer, Attorney Mendoza, before the Sandigan Bayan?
What I remember, Your Honor, is for the accused to be granted...
The motion was to fix bail, considering the mitigating circumstances, surrender, old age. What was the ruling of the Sandigan Bayan? Let us see if you will still agree.
Well, Your Honor...
The Sandigan Bayan denied.
Yes, Your Honor. That is why it was
Then Attorney
brought before
Mendoza
the
went
Supreme
up to the
Court.
Supreme
That's
Court
right,
on
Your
a
Honor.
petition for certiorari.
Yes, Your Honor.
As what you said, Justice Bersamin considered the following factors: old age, no risk to evade arrest, and number 3, being a public official. Are those factors or grounds in accordance with the Constitution? Because when you go up there, you know that. First, you will determine what law is applicable. The Constitution is applicable. So therefore, Justice Bersamin, practically violated the Constitution.
Your Honor...
There was no hearing yet whether or not evidence of guilt was strong.
Your Honor, I...
By the way, what was the reason of the Sandigan Bayan for dismissing or denying the motion?
Well, Your Honor, the Sandigan Bayan cited the exact provision you just mentioned. No?
No, the Sandigan Bayan denied the petition for being premature because at that time Enrile was not yet arrested. Imagine, under the circumstances, the Supreme Court readily granted the bail. I think you should review first the decision. Attorney Marquez, I dissent. Go to the decision in Marcos Burial. What was the legal basis relied upon by the Supreme Court in allowing the interment of Marcos in the libingan ng mga bayani?
Well, Your Honor, the court said that there was no prohibition. No?
No. Armed Forces of the Philippines Regulation 375.
Well, yes.
What is that regulation all about? Who are entitled to be buried?
The president, of course, and then he was also a former soldier.
Secretaries of National Defense, chiefs of staffs, soldiers, etc. But there are 3 exceptions. People who cannot be buried there. What are these 3 exceptions?
Those who have been guilty of certain crimes, Your Honor, even if they have been
Those guilty of crimes involving moral turpitude. Next. Those dishonorably discharged
yes, Your Honor.
by the military tribunal. And number 3. Okay. For number 3, we will just consider these 2 reasons. Was he dishonorably discharged?
Your Honor, he was not dishonorably discharged.
Yes, he was dishonorably discharged by the people themselves. Did he commit crimes involving moral turpitude?
Well, Your Honor, I don't think there was a case that...
Yes, tortures, murders, rape, homicide. My goodness. That's why there was people revolution.
yes, Your
Well, you
Honor.
have your own opinion, I have mine.
Yes, Your
Let's
Honor.
go to martial law. If you are now the ponente, how will you decide the petition? Questioning the constitutionality of the declaration of martial law. Because, number 1, Congress did not convene, and number 2, whether or not there is factual basis. Okay, please decide on these 2 issues. You are now a justice of the Supreme Court.
Your Honor, Section 18 is, of Article 7 is quite clear. I think they will have to convene if they will either revoke or extend the 60-day period allotted for... or
After declaration, how soon will both houses convene?
Well, after declaration, within 48 hours, the President must submit to both houses the reasons for imposing martial law.
A report in person or in writing?
In writing, Your Honor, yes. And then it will be up to Congress to decide whether it should convene jointly for the purpose of either revoking or extending the martial law. From me,
There was yet no request from the President to extend. So in other words, because both houses did not convene, what is now your...
yes, Your Honor, and
your
in fact,
decision?
both houses came out with a
As
separate.
ponente, will you order them to convene this late?
No, Your Honor, I don't think that can be done under Section 18 of Article 7 of the Constitution.
Why? Because 48 hours have lapsed?
No, Your Honor, because there is nothing there that authorizes or empowers the court to require both houses to convene. No?
Meaning the Supreme Court is powerless to order Congress to convene? How about expanded jurisdiction?
No, Your Honor, the court is not powerless. Under Section
Under
1.
Rule 65.
Under Rule 65 and under Section 1 of Article 8 of the Constitution, the expanded jurisdiction of the Supreme Court is very clear. No? But then again, the court will have to...
Determine whether or not the President...
there was grave abuse of discretion amounting to lack or excess of jurisdiction.
So the Supreme Court is not powerless, yeah?
Yes, Your Honor, but...
Do you think the Supreme Court can still convene both houses? Do you think the Supreme Court can order them to convene?
Well, it's more than, I think, almost a month already. No? So...
But the Supreme Court has retained its power under Rule 65.
Yes, Your Honor.
What
yes.
do you think what will be your decision? You are the ponente.
Well, Your Honor, if I will be the ponente, my view will be...
View, your own conclusion,
My
your own finding.
my opinion will be... My own finding will be...
On the basis of the Constitution.
That's right, Your Honor.
Article 8, and Section 8, Article 7.
I will have, well, it will have to be based on Article Section 18, Article 7, no? And then, of course, vis-a-vis the power of the Supreme Court under Section 1, Article 8, no? The expanded power of the Supreme Court. But then again, as I've said earlier, this has to be studied very carefully. No?
Have you studied it? That's why I'm asking for your decision.
Well, yes, Your Honor. My view is that my decision will be
Because you are the ponente. Let us see if Justice Bienvenido will dissent or concur. Your
Well-
brilliant boss
well.
who has tutored you all these years. Okay, let us see.
Yes, Your Honor.
What will be your decision? You are now the ponente.
My decision is I don't think there is a need for both houses to convene if
Nobody will determine whether or not there is factual basis for the
No,
declaration of martial law. If there will be no, if you will not convene both houses.
I think Your Honor, the two issues have to be
How will
separated.
you? Are you evading the Constitution?
No,
or
Your
you
Honor.
will not apply the Constitution
No.
anymore?
I think the two issues have to be separated. The first issue is whether or not they should convene after 48 hours when they receive the report of the President. Should they convene immediately, motu proprio, upon receiving the report? That is the first issue. And second, is the court authorized to look into the factual basis of imposition of martial law? For the second issue, I think there is no... Okay, for the first issue, I think the court need not, or the two houses need not convene after receiving the report of the President.
Why?
It will only convene if it will revoke the imposition.
No, it will convene to determine whether there is a factual basis for the declaration of martial law. Until now, there has been no finding by Congress that there is no factual basis.
Your
And
Honor,
there is no prohibition right now for them not to convene or to convene.
that's right, Your Honor.
Who will determine now if there is factual basis? The Supreme Court?
No, Your
Factual?
Honor. That is why.
Decision of the Supreme Court should be based on the findings of Congress. Don't you think so?
Yes, Your Honor, based on the findings of Congress and also...
You said Congress will not convene. Okay, that's the end of the question. Prepare your decision now. We will wait for it and the dissenting or concurring opinion of Justice Bienvenido. Thank you.
Well,
Good luck.
Your Honor, I hope I get to vote in that case.
All right, thank
you,
you.
Your Honors.
Thank you, Student Marquez, and thank you, Professor Justice Gutierrez. Thank you for your time.
Call the next applicant.
And the next to be interviewed, Your Honor, is Court of Appeals Associate Justice Apolinario D. Bruselas, Jr. Justice Bruselas, Your Honor.
Okay, good morning, Justice. Good morning, Your Honor. So we will start. May we request Judge Ilaw?
Excuse me, please sit down.
Thank you.
Hello, good morning, Justice.
Good morning, Your Honor.
You have been an Associate Justice in the Court of Appeals for how many years, Justice Bruselas?
This is my 12th year, Your Honor. 12 years.
So what is the most difficult challenge you have faced on your career as a Court of Appeals Justice?
The most difficult challenge that I faced, Your Honor, is in the matter of deciding cases which are of national significance. I have had an encounter of about several cases. I recall one case involving the Lance Corporal Smith about 2008, which involve U.S. RP relationship. So to me, that was quite a challenge, but I was able to overcome the challenge. I remember that our decision there in the Court of Appeals was eventually sustained, although modified, by the Supreme Court. This case involved Lance Corporal Smith accused of raping a Filipina in Olongapo, in Subic Bay, Your Honor. And there was quite a tug of war involving RP-US relationships, Your Honor.
So what did you learn from it?
The lessons that I learned from that experience is that judging is not limited to books or I call to mind my late philosophy professor, legal philosophy. He coined a word concerning, he called it obluchaks. These are an acronym for matters which a judge may consider in deciding a case. And what does this mean? He has in mind O, opinions, B, beliefs, L, longings, U, usages, T, traditions, I, idiosyncrasies, A, aspirations, and customs, and he says, even as superstitions. Of course, these are what we call extra metalegal stimuli that come into play when a judge sits down to study and make a decision. Of course, always within the legal framework of a case. But these are factors which come into play also, Your Honor.
So what are you willing to sacrifice for your career? Quality time for your family?
In my 12 years as a Court of Appeals Justice, 8 years as an RTC judge, 8 years as a public prosecutor, 3 years as a serviceman, sacrificing time or balancing time, to me, I have been able to take care of that. It's not really a question of sacrificing, but it's a matter of managing time. Certainly, one cannot say that just leave the family behind and let the Lord take care of them and concentrate on one's career. I am not of that view, Your Honor. I am of the view that time can always be managed, and whatever aspirations one may have, he will have to reckon with the necessity of taking care of his family and at the same time also advancing his career.
Sir, what do you consider your greatest failure in life?
Greatest failure, I would not say a single greatest failure, perhaps a number of little failures, Your Honor. One, perhaps...
not being appointed as Associate Justice of the Supreme Court despite so many tries?
This is my third interview, Your Honor. I would not consider that as a failure, Your Honor. I would consider that as simply an experience. So little failures, I would say, well, aspiring for, in the barracks, in the College of Law, because I was a working student at the time, Your Honor, I was trying to manage work and study at the same time. So I was a working student. And then came the bar exams. I recall that I simply relied on stock knowledge. My failure is that I did not study further to make, to top the bar or, make a better impression in the bar exams. To me, that is one of those failures. I could have done better. That's what I'm trying to say, Your Honor. Except that I failed to do better.
All right. On hand is an opposition. A letter dated June 15, 2017 by a certain attorney Malyari. Do you know him? No.
I was just apprised just before I stepped into the room about that complaint. But this attorney Malyari, this case, I know him because he has initiated a complaint since 5 years back. The Supreme Court has already ruled on that matter, Your Honor. As a matter of fact, as I recall, the last issuance of the Supreme Court was for him to explain why he did some things concerning his case. That is the last. With respect to the complaint against us, it has been resolved, dismissed by the Supreme Court. And unfortunately, Attorney Malyari persists in coming up with an opposition based on the same ground that he has raised as early as 5 years ago, Your Honor.
But did you receive a copy of the letter?
I just got it this morning as I stepped into the room.
Okay.
It's the one, Your Honor, and I have not been able to peruse it. But I surmise that it is the same thing that he has raised over and over again. It's really difficult for a judge because a judge cannot satisfy everybody. The judge, when he makes a ruling, one loses, one wins. And sometimes parties take it personally.
All right, Attorney Malyari is present in this room. Are you Attorney Malyari? Okay, please sit down. Thank you. And some cases and complaints filed against you, yet you did not disclose it in your personal data sheet.
I am not aware of any other cases, Your Honor, filed against me where I was disciplined, Your Honor. The query, as I recall in my information sheet, is that have I ever been administratively disciplined by the Supreme Court? There have been initial preliminary inquiries, but these were, we call them IPIs, but they were never administrative cases. I was never administratively charged by the court to file an answer, Your Honor.
Don't you think that as a magistrate, you must be extra cautious, taking care of it? That one has not to be called upon to answer, to comment on cases, complaints against the magistrate?
With respect to being called upon to comment, Your Honor, as I know it, when we are not asked to comment by the Supreme Court, in fact, we do not even get to know about it until we receive a resolution dismissing a certain complaint or a certain letter of complaint. That's why, Your Honor, I would not be in a, if you're asking whether or not did I omit to say anything in the PDF, I'm saying that I did not omit anything of any answer at all that should be stated in the PDF. That's the PDF that I have submitted ever since, Your Honor.
All right, on the other side of the fence, in your 34 years in the practice of law, what can you say is your defining moment, your greatest accomplishment, which makes you worthy of the coveted position?
Well, I can remember, Your Honor, that in my years as a trial prosecutor, whenever I encounter a case concerning an accused who should not have been brought to trial, as a prosecutor, I would myself move for the dismissal of that case. To me, that is a defining moment for a public prosecutor. When he not only prosecutes, but he refrains from persecuting, because a prosecutor prosecutes. As a judge, as a magistrate, Your Honor, my defining moment is that, you know, this, as I said, these cases that I handled, which involve national interests, I have been able to overcome that without involving any party to an imbroglio, Your Honor. And to me, being able to resolve a case that has impact on our international relations, to me, that is something that one should really be proud of, Your Honor.
Sir, what had been the notable achievements of the Computerization, Library, and Modernization Committee of the Court of Appeals under your watch as chair?
Well, not to brag about it, Your Honor, but the e-courts project, which is now being pushed by the Supreme Court, took off from that automation in the Court of Appeals. In other words, we trailblazed automating court processes. Right now, the Court of Appeals, not only in Manila, but to include the branches in the stations in Cagayan and Cebu are automated. Meaning to say, we are able to look at the aging of our cases, process them, and on real time, indicate once a case is decided. As a matter of fact, Your Honor, it's online. No? If you access the CA website, you'll be able to find out if you are a party or a counsel or litigant, find out if you know your case number, case title, you can find out the status of that case in real time. You may be abroad, you may be in Saudi Arabia, you may be in Taiwan, and you can access that without having to go to the Court of Appeals. That is a real achievement. And as a result of that, we increase transparency, we also increase efficiency. So instead of relying on the old records, index cards, looking for old files, one has simply to sit before a computer, a terminal, open it, and enter our website, our network site, and we can start processing cases.
Arat, I can have a last question, Justice? Yes. Arat, although my time is up, but what is your platform for the Supreme Court if and when you are appointed as an Associate Justice?
Platform for the Supreme Court? Well, I will only be one of 15, and probably my ideas cannot really influence the others, but what I have in mind, given the opportunity of being appointed and probably being able to work with colleagues and more or less convey to them certain things of doing things, what I can say is that we should push that e-courts project. We should not let it dry in the grapevine, so to speak, so that we can enhance transparency and efficiency. And perhaps, in a manner of speaking, perhaps I can, because my school of thought is that allowing in an environment where the courts work within a system where there is the executive and the legislative branches, my idea is that one of judicial restraint, to me, it may be important, especially at these trying times, for the courts to exercise restraint, even as it forges forward in trying to perform its duty under the Constitution.
Well, I found it advisable for you to file your written comment on the alleged opposition of Atty. Malyarin.
I will do that, Your Honor, as soon as I leave this room, except that I was just furnished that letter just today as I stepped into the courtroom. It's in this envelope, Your Honor, that I just saw. My staff gave it to me. And I never saw this until this morning, Your Honor.
All right. Thank you. And good luck, Justice.
Thank you very much, Your Honor.
Thank you so much, Judge Ilaw. May we request now Attorney Mejia to continue.
Thank you, Madam Chair. Good morning, Justice Bruselas. You have been shortlisted and interviewed numerous times. Can you tell us any significant development in your career since your last application?
The most recent one, Your Honor, is that I have been tasked to head a technical working group to come out with what we call rules of procedure on cybercrime. We have just finished, after 3 months' work, the group that I headed, we have just completed what we call now a proposed rule on cybercrime warrants. Because we now have a cybercrime law in 2012, and the court has still to provide the procedures for implementing the various modes of investigation, interdiction, and processing of cybercrime. And this is what we came out with, Your Honor. This rule on cybercrime warrants will spell out the procedure for applying for an officer to disclose computer data, to examine computer data, and to intercept computer data. The law which was passed, 175, was not very clear about it. So we had to look at that and the other laws and come out with this rule on cybercrime warrants, which will hopefully guide the courts, trial courts, and the prosecutors, and even the service providers of how to go about their work under the RA 10175. Cybercrime now is very, very pervasive, Your Honor, and that's why the court tasked us to be fast on this. We have finalized the rule, and that is the latest, Your Honor, that I have accomplished so far. Of course, continuing is the e-courts program. We have already automated 10 sites, 10 trial courts, clusters, no, all over the Philippines. We have Quezon City, Manila, Mandaluyong, Pasig, Makati, Cebu, Lapu-Lapu, Davao, and 2 more, Your Honor. And the intention now is to program to propagate this to all other sites all over the country, to cover all courts eventually. But it needs a lot of financing, Your Honor. Right now, we are being aided by our development partners, primarily the USAID, and coming in after that will be the European Union, Your Honor. And of course, we have also, the Supreme Court also has proposed in the GAA funding for this project, Your Honor.
So may I also propound the questions tweeted, no? Do you believe that a parent's consent is required for a girl, I'm assuming a minor girl, to access contraceptives? Your view, please.
A minor at what age? Below 7, Your Honor? Naturally. Above 13 probably, no, of puberty. A minor below 18. Should she obtain the permission of her parents to use contraceptives? I am on the conservative side, Your Honor. I am of the view that minors should obtain parents' permission on such a matter of contraceptive. Not only because of that matter of being conservative, but I recall the constitutional provision which highlights the right to life and contraception as we know it. Of course, there are several views on the matter. No? Contraception interdicts possible life.
The martial law declaration, then really bail and the Marcos burial. Briefly.
On the martial law declaration, Your Honor, to me, the executive has all the powers to do that. If, as the Constitution says, if there is invasion, rebellion, whenever public safety requires it, the executive has the duty, in fact, to make that declaration. If in his perception that is required, of course, there's a check and balance there because the Constitution also allows the Supreme Court in an appropriate case to inquire into the factual basis of that martial law declaration. So now, then again, we recall that the Constitution also says that Congress may, in a joint session, may revoke such declaration. So there's again another check and balance there that Congress can come in and say, we do not agree with your declaration, Mr. President. And then the other point there is, within 24 hours, if Congress is not in session, then they must meet to look at that, whether there was a correct appreciation of the President to declare martial law or not. The academically, rather, it's not being disputed whether or not Congress should still sit when, in fact, they have already come out with the resolution, in effect, approving or seconding the President's declaration. So to me, that matter, because Congress, when Congress issued the resolution, Congress was in session at that time. So to me, they can very well do that. Now, right now, there is a case pending with the Supreme Court on the other, as I said, for the other matter of this other check and balance where the Supreme Court can inquire into the factual basis of that determination. So you now have three assessments, the executive, the legislative, and the Supreme Court. We have now the executive saying there's factual basis, the legislative saying we agree that there's factual basis, and now it's being contested before the Supreme Court. The other matter of the bail,
And the mark
with respect to the bail given to Senator Enrile, that is really to me, as I reviewed our jurisprudence, that is really an exception. An exception in the sense that bail has never been given on the basis of the court there said, I think, humanitarian consideration. Bail is a matter of right, except only when the case involved is punishable by recollection perpetua, where the evidence of guilt is strong. When those 2 points are satisfied, bail is denied. So when you go to another ground for granting bail, that's something unique, Your Honor. On the matter of the Marcos burial, again, this is an exercise of the executive prerogative, Your Honor. And to my mind, well, if I recall, that has been settled already by the court. And to my mind, as I said, I am more on the restraint side of the issue. So long as there is no grave abuse of discretion, the court should better leave it to the more political organs of government. After all, these are the organs of government that have been elected into office. Now, to bring a little point, if Your Honors will permit, why do I harp on this judicial restraint? There is now a development in the U.S. about counter-majoritarianism. This school of thought seems to say that we should, there are thinkers who say that an elected group of individuals, no matter how they may be experts in, should not be able to make a decision that will counter decisions of those who are elective. That's why the term counter-majoritarian. If the Congress is a majority, then you have a group of 15. A case comes out, and the decision of that 15 supersedes or overcomes the majority, then that is counter-majoritarian. But this is just a school of thought, a theory, Your Honor, that is being studied now.
Thank you. That was my final question. Good luck again, Justice Bruselas. And
Thank you very much, Your Honor.
Thank you, Attorney Mejia. Okay, good morning again, Justice Bruselas.
Good morning, Your Honor.
Of course, you know the rules of the JBC, and one of the rules states that in determining the qualifications of candidates or applicants, the candidates' mastery of laws, rules, and jurisprudence must also be tested. Okay, let's go to this boiling issue concerning the maritime dispute between the Philippines and China. Do you agree with the statement of President Duterte that the Philippine Navy should not patrol anymore the Philippine Economic Zone, but only the Philippine Territorial Sea? Do you agree or you don't agree?
The Constitution mandates the armed forces to be the protector of the people and the state. Because of that provision, the duty of the armed forces, to include the Philippine Navy, their duty is to ensure territorial integrity. So when you say if the commander-in-chief commands them not to patrol, that may be a little bit in collision.
We are
with
talking
that
here
provision.
of not security of the people, but the marine wealth.
That's correct, Your Honor. The integrity of the territory, which includes the territory, includes the
Yes,
marine resources.
In dealing with foreign nations, the Philippine government should protect and preserve its territorial integrity, especially its marine resources. Okay, so that is the provision applicable there. Do you also agree with the statement of President Duterte that the China's claim over the South Philippine Sea has historical reason because of the name South China Sea? Considering that the name is South China Sea, therefore China has a claim on that part of the maritime territory because of the name. So what will be your answer to that?
I don't think that is very, very accurate, Your Honor. Because it's named South China Sea, therefore it belongs to China. It belongs to China. So my view, that's not a very accurate statement. In fact, there is no, I have done some reading about the matter. There is no deep historical basis for the claim of the Republic of China that this territory that they're disputing, you're talking about parts of the Spratlys, etc., have been historically linked to them. There is no such basis, Your Honor. So I respectfully...
Have you read the UNCLOS, United Nations Convention of the Law of the Sea? So what does it provide with respect to that issue or incident?
I think Section 50, 54 of that provides the mechanism for disputing states to settle precisely this.
Name of the sea has no bearing.
That's correct. Your Honor.
Name of the sea,
as I said
the provision
earlier,
of the UNCLOS has no bearing on the source of marine wealth or
I said earlier, Your Honor.
acquisition there. Okay, so let's go to the ICC. Considering the extrajudicial killings and the enforced disappearances happening nowadays, do you think the International Criminal Court under the Rome Statute can acquire jurisdiction over the Filipinos involved?
The Rome Statute, which created the International Criminal Court, Your Honor, as I recall, indeed, individuals may be subject of that, but that is not the general rule. The ICC comes into play only when affairs in a state, a member of the UN, go out of hand.
A member
Yes,
who
a
signed
member.
the ICC.
Yes, a member state. The affairs in that member state go out of hand in a sense that the current administration or government is unable to function as a member of the UN, according to the UN standards. That is when one may have a recourse to the ICC.
Unwilling or unable?
If a state is a member of signatory
Okay, let us see the present situation now. Is the Philippine government unwilling or unable to suppress or prevent these current extrajudicial killings or enforce disappearances?
That's what I said, Your Honor, when the affairs in the state go out of bounds. Under the
Just
current,
let me know. Is it unwilling, unable?
under the current situation, Your Honor,
Why?
I don't think this current government is unwilling. Number two, it is also not unable. As a matter of fact, it is spending resources to be able to ensure that these so-called extrajudicial killings do not go out of hand. It is a factual, empirical issue, actually.
What actions has the government done for you to say that it is willing and able or unwilling or unable?
First, if you will note, Your Honor, there was an immediate order dissolving because of reports that the dangerous drugs units of various police officers have been, exceeding their powers. This was dissolved. That was the immediate action of the government, to dissolve the dangerous drugs action units of the police and to organize a new one. So to me, that is a step in the direction of addressing that excesses. So
If you remember, Justice, the Senate conducted an investigation headed by Senator Gordon. What happened?
I am not aware of any report having been circulated yet, but the media reports about that Senate investigations that it seems to the Senate
The
that
witnesses were
witnesses
considered not credible.
Witnesses
Okay.
were perjuring themselves. That's what the media report said, because they were flip-flopping. They were they were saying this and then recanting later on. So the testimony, as the Senate saw it, was not that credible. So there was not much progress in that. Your
Again,
Honor.
why do you say the government is willing and able? What action has the government done
If you
aside from that investigation?
the very fact, when you talk of government, you talk of the entire the branches. The very fact that the Senate, in fact, on
An
their own,
impeachment complaint has been
conducted-
filed against the president, meaning to say there is an action being taken.
The processes are working. The Senate has investigated, and there is a next process, which is impeachment, that is on track, Your Honor. The very fact that the Senate is able to conduct investigation, although perhaps the result may not be to the liking of some people, the fact that there is a Senate investigation going on is an indication that something is being done. The very fact that the courts, the Supreme Court, and the other courts are functioning fully also indicates that the government is not lagging behind in its duty to serve and protect the people.
So according to you, there are actions being undertaken by the government to
Yes.
prevent extrajudicial killings and enforce disappearances. But until now, these events have been happening. Do you agree or don't agree?
Actions and processes are taking place. The results of these actions, we may not agree with the results, but what I'm saying is there are actions and processes being allowed to happen, and these are not being suppressed. Now, whether or not we agree that
That's
these
why
are
I ask
enough,
you, what are these processes? We only consider what is that? The revamp at the PNP.
that one, the solution.
Let us say,
of-
what is or what are the differences between these two laws? International humanitarian law and the Declaration of Human Rights adopted by the General Assembly on December 10, 1948.
They may both contain humanitarian, but they are quite different. The international humanitarian law, that is actually the law of war. We used to call it the law of war, Geneva Convention. The UN International Law on Human Rights actually sprang from the experience in the Second World War, where there were millions mass killings of Jews. This was a reaction to that sad event in the world history, that millions of inhabitants were killed, experimented on. So, international humanitarian
6
law.
million Jews were killed.
That's right, Your Honor. International humanitarian.
So the basic difference is the international humanitarian law
laws of war.
governs
The laws of war.
situation during war.
Yes, Your Honor.
But at the same time, Declaration of Human Rights also apply to civilians, quote, because of the wars.
the
And this
human rights.
international human rights law applies only during peacetime. Okay? Do you agree?
The international humanitarian law, no, Your Honor, our constitution, and we have already laws which have been enacted, special laws, which
In fact, the Constitution provides
yes, ensure that
we protect human rights.
that's right, Your
So I'm
Honor.
just only asking about the difference or differences, meaning to say even the Declaration of Humanitarian Law also applies during war. Declaration of Human Rights also applies even during war. In what way?
International human rights apply. Yes, Your Honor.
During war, how?
Yes, precisely because
How? How does it apply? How does it protect people
the Declaration of Human Rights.
during war?
Well, precisely, they call it protagonists, those who are armed elements, are precisely prohibited from doing the mass killings, even to include mass destruction of edifices. So not only life,
Meaning
even
to say
property.
civilians are being
Yes,
protected
yes.
even during war.
Not only combatants.
They're being placed, outside the battlefields. So that's one way of applying the Declaration of Human Rights. About this, the bail granted to Senator Enrile, if you were a member of the Supreme Court, would you have dissented or concurred? I did not get your answer a while ago.
As I said, it was a...
Will you concur? Will you dissent?
Under these circumstances, I would not have concurred with that decision, Your
You
Honor.
will concur.
I will not have concurred.
You will not concur. So you will dissent. Why?
As I said, Your Honor, the ground used was
First of all, apply the Constitution. What is the provision of the Constitution?
Well,
Diba? When you
bail-
write decision,
bail
you
is a
look
matter
for
of-
the law applicable.
Yes, that's right. Bail is a matter of right. Matter of right.
So all accused are entitled
except-
to bail except those charged
only,
with capital
yes.
offense when
And
the evidence of guilt is strong.
Those are
Okay,
the
what
only-
happened to that case
As I, it was,
for the
it-
Sandigan Bayan?
that case of Enrile,
Yes, what was the ruling of the Sandigan Bayan in denying the motion of Atty. Mendoza? And what was the motion, by the way?
precisely, as I recall, the motion was petition for bail, no? But the Sandigan Bayan denied
No,
it.
motion to fix bail, not to grant bail, to
Yes.
fix bail. Okay.
Yes. But
What happened
it's
next?
The terminology
How
used.
did the Sandigan Bayan take action on that motion to fix bail?
The term used by Attorney Mendoza is motion to fix bail because on the theory that the right bail is a matter of right, that is what he used, motion to fix bail.
No, there was no motion for bail, but motion to fix bail on the ground that there are already mitigating circumstances attendant to the commission of the crime. Number one, old age.
That's right. That's why I said.
Number two,
seniority
according
in
to
years.
Mendoza.
Yes.
So what was the ruling of the Sandigan Bayan, Justice? That's my question.
Sandigan Bayan denied it, I think.
On what ground?
Because these are not grounds found in the Constitution for
No, the
allowing
ground
bail.
is one. Prematurity. It was premature to Enrile to file that motion because he was not yet arrested. That was the ruling. And then the Supreme Court, what was the ruling of the Supreme Court? The Sandigan Bayan committed grave abuse of discretion. Why? Was there a grave abuse of discretion by denying that motion? That will be the subject of your dissent, di ba, Justice?
Is precisely with the jurisdiction of the Sandigan Bayan to act on that petition to fix bail. That the Sandigan Bayan decided differently does not mean to say that it abused its discretion. As a matter of fact, it
There was no
exercised its
abuse.
discretion.
There was no abuse of
That's
discretion
what I
because
said.
the motion was premature.
That's what I precisely said, Your Honor. The term used by Attorney Mendoza was petition to fix bail. The proper term is petition for bail. But he used petition to fix bail because he was of the theory that bail is a matter of right.
No, what will be your grounds of dissent against the decision of Justice Bersamin? Okay. First ground. You dissenting?
I will dissent on the narrow ground that the basis for granting bail has not been satisfied. And second,
The Constitution is very clear.
that's right. The second, if it's a matter of discretion, there has not been any showing at all that the Sandigan Bayan, the trial court, much more gravely abused its discretion. The fact that the court decided one way does not mean to say that it abused its discretion. That
Because there was no whimsical or
arbitrary, capricious, or whimsical
showing.
action.
Okay.
Yes.
Very much, Justice. Good luck.
Thank you very much, Your Honor, for the opportunity. With your the court's permission to leave. Thank you, Your Honor.
Next to be interviewed, Your Honors, is Court of Appeals Associate Justice Rosemary D. Carandang. Justice Carandang, Your Honors.
So, good morning, Justice. How are you today? Fine.
I'm supposed to be
Anyway,
good.
We will now call Judge Ilaw to start.
Thank you. Justice Gutierrez, good morning, Justice.
Morning, sir.
All right, do you agree that justices must... All right, can you still rest for a while? Are you okay? Let's take it.
I've been drinking water.
Diabetic?
No.
Okay.
No high blood, no high sugar. Good health.
Okay. Do you agree that justices must continuously improve themselves and always keep themselves abreast of recent legal developments?
Of course, that's the very first thing that a judge should know, or a judge or a justice should be doing, because competence is, aside from independence, which is number one, competence is the next value that the judge must bring to herself. We have to do a lot of readings. We have to do a lot of studying. For me, law is law and the judging is a profession that should not stop one in getting new developments, new principles, new jurisprudence. It's a never-ending line to. We should not stop studying.
So, what activities do you engage in to achieve this, since your personal data sheet does not enumerate the seminars you attended?
It's quite numerous. So I have been attending several seminars sponsored by PhilJA, Court of Appeals seminars. I always attend that. Seminars on anti-money laundering, seminars on the writ of amparo, writ of kalikasan.
But you were required then to, as one of the requirements of the JBCs, to indicate, enumerate seminars, teachings, and if it's not enough, you can attach or
sorry,
additional sheet.
I'm sorry, sir, I was not able to do that because in my prior data sheet, that's all the thing that I indicate, and I have never been asked to indicate all the seminars, all these things that I have attended.
All right, as chairperson of the Committee on Rules of the Court of Appeals, what changes have you implemented that have effectively complemented the work of the Court of Appeals?
It's not actually my work, it's the work of a committee. And then lately, we are polishing our rules on anti-money laundering in relation to the new jurisprudence and to the new amendments that the law has been undergoing. Basically, there is not much because the rules of procedure of the Court of Appeals are more or less stable. It is patterned after our rules of court. So it's only just a procedure of how to adjudicate, how assignments are being given. So it's not much of a substantial change that we really do. And lately, what we did is since the Supreme Court has directed that similar cases must be consolidated, we formalized that into a new rule, which is for submission to the Supreme Court in bank. But we have been doing that already for the last 2 years.
All right, at hand is a Twitter question. As a member of the Court of Appeals, why do you think it has such a poor reputation?
Do we have a poor reputation, sir?
And that's according to the question.
I don't think the Court of Appeals has a poor reputation.
Why do you say so?
We have been doing our work the best. If there are if there are bad news coming out, I don't think it is directed to the Court of Appeals as an institution. Maybe it could be directed to other members of the court. So it's very unfair that the institution of the Court of Appeals is blackened as a whole.
All right. It is the Judicial and Bar Council policy to disqualify applicants with pending cases. But you have a pending case in the Supreme Court. A complaint filed by a certain Norberto Villamin and Eduardo Balse, with an affidavit relative to CAGR Special Proceeding Number 147998. Are you aware of this?
Of course, yes, Your Honor, because we have been asked by the Supreme Court to comment on that, and this is not being converted into a regular administrative case. If I might go further, this is the application of the condonation doctrine applied in the Binay case. The complainants are saying that we should be administratively held liable because the judgment of or the orders of the Ombudsman are executory and cannot be enjoined by the Court of Appeals. This refers to the act of the Governor of Camarines Norte, which was done in 2010, and he was re-elected several times. And the reason why we, my division issued the injunction order is because of the application of the condonation doctrine, which is still applicable because the application of the condonation doctrine is prospective in character.
You said that you're aware of this and you were required to file a comment by the Supreme Court.
Yes, sir.
Did you comply with the
Yes, sir. Yes, sir.
But the records of ours do not indicate that you had complied with such in-bank notice dated January 31, 2017.
I have, sir. In fact, it's included in my.
May I interrupt for a while? So that is judicial in nature.
Yes, ma'am. There's nothing.
Has there been a pronouncement that has been a judicial
No,
in character, that's judicial in nature?
Yeah, because it is related to our action to issue a temporary restraining order and injunction to prevent the enforcement of the dismissal order of the Ombudsman.
Do you have a copy of it?
Yes, Your Honor. I think it's attached in my. It's good that I brought it with me. I have a singular copy here with me, sir.
Arata, can you furnish the council a copy of that later on?
Yes, sir.
So,
This is not a regular administrative case yet. It is still going on.
The merits.
Yeah, yes, ma'am. It can be dismissed outright. So thus far, we were only, because we were many, we were many who were accused by these people. Each and every one of us who issued, because there are so many cases against that governor. So each and everyone who adopted that doctrine and issued the restraining order injunction were subjected to this similar case. And I consider this case as a harassment case because this is in connection with our performance as Justice of the Court of Appeals. And the basis of our order is the condemnation doctrine, which is prospective in application, and this has been applied and ruled by the Supreme Court in the case of Binay.
Thank you. I hope you won't mind that. How young are you? Already 61 years old?
No, I'm 65.
65?
I'm 65.
Sorry. 65 years in service?
No.
Sorry.
I'm 65 years old. I have logged 14 years in the Court of Appeals and 9 years as RTC Judge of Manila.
See. Still single? Why?
I still bear the surname of my father.
Karandang.
Apo.
The famous Karandang family in Batangas.
We are not famous. They are famous. We are not famous.
So you're infamous.
No, I'm not infamous. I'm not very well known because my parents are just simple people.
Okay. All right, thank you.
Parents
My
are
time is
just,
up. Thank you very much, and
Yes, sir.
good luck.
Thank
you
you,
very
Justice.
much, Judge. And now the turn of Attorney Mejia, please.
Thank you, Madam Chair. Good morning again.
Good morning, sir.
Justice Karandang. You've been interviewed a lot of times already, and you've been shortlisted actually also several times. Can you tell us any significant development in your career since your last nomination?
I don't think there is much significant development because I just continue to work as a judge. There is nothing that came into my life from the time I was last interviewed, except this filing of the administrative case against me last January.
Okay, thank you. So let me, having asked you several questions before, let me give way to the tweeted questions, if you don't mind.
Yes, sir.
Let me ask you the questions which were asked earlier. If we can get your views very briefly on number one, the martial law declaration, then really bail, and the Marcos burial.
Martial law declaration is sub judice. So what I can rant in is the power of the president to declare martial law in case of rebellion and invasion when public safety requires it, and then he can just do it for the period of 60 days, and Congress has the power to revoke it, or at the initiative of the president, that declaration can extend beyond the period as granted by Congress, and the president has to report, which the president did, submitting a written report of his declaration 48 hours after his declaration, and that was done. And then together with the declaration is the suspension of the writ of habeas corpus, which will only affect arrest of people who are probably guilty of rebellion and crimes incident to invasion. And then, of course, there are pending cases with the Supreme Court regarding asking the Supreme Court to rule on the factual basis for the declaration of martial law, and some would question whether the declaration must cover the entire Mindanao or only the city of Marawi.
Then bail.
Really bail. I am not for that because the grant of the bail to Enrile is not among the grounds under the rules of court and under the Constitution. Health, maybe the good reason is because of his old age. And as we have seen, he has never left the country for the time that he was granted bail up to now. So the fear of the government in, of course, refusing bail, and that is the reason why, is the fear of the government of evasion of prosecution by the accused. And this will not happen because we have seen that for Senator Enrile, who has been in the country from the time that he was granted bail up to now. And I don't think I don't think he even sought permission to leave the country from that time on.
Is there any other Supreme Court decision with which you disagree, and please explain why?
Of course, the right to bail on cases which are carrying penalties of life imprisonment or higher, when the guilt of the accused is strong, the accused is not entitled to bail. So that is our standing jurisprudence, and that has not been set aside except in this case for humanitarian reason.
What is your reaction to the threat of Speaker Alvarez to have the CA abolished?
I think it was a expression of dissatisfaction on what the Court of Appeals did, but we have to, I think he was emotional on that matter. It's not very easy to dissolve our courts because in that case, that will be against the Constitution. In fact, there is a prohibition from Congress to undertake reorganization if it will dissolve, if it will affect our tenure of office. So there are so many ways, but dissolution of the Court of Appeals, I think, is not a warranted action, and it should not have been aired by no less than the Speaker, because he's a lawyer, he's the Speaker of the House, he must know the limits of our power. Of course, we know the limits of the legislature also, the rights of the legislature, but he should respect also the authority of the court in hearing these cases, because this is a habeas corpus case.
Another tweeted question, and this will be my final question. Do you see the Philippine courts being independent of the executive and of the president? And how will you be independent?
Of course, that is the very number one quality, independence. Of course, the judge has to look at the case, apply the law on the particular facts of the case, and then the judge also has to look to the letter and the spirit of the Constitution, to the letter of the law, and that is our guide in deciding cases. So the separation of power is something that we have to respect also. The president has his own sphere of influence, so as the legislature, and they have also to respect our sphere of influence in deciding cases that might be not to their liking, because the court has the expanded power of determining whether any act of the legislative or executive branch of the government is in excess of jurisdiction or with lack of jurisdiction. So on that basis, I don't think our president is a lawyer. He knows that. He knows the separation of power principle because that is ingrained in our government. And in fact, he said that lately he said that if the Supreme Court would declare no factual basis for the declaration of the martial law, he will abide by it.
Thank you. That was my final question. Good luck again, Justice Carandang, thank you, Madam Chair.
Thank you, sir.
Thank you so much, Attorney Mejia. Good morning again, Justice.
Good morning, ma'am.
So, simple questions only on legal matters.
Yes, ma'am.
Because the rules provide that the candidates' qualifications must be determined also by testing their mastery of laws, rules, and jurisprudence. Anyway, let us go back to the case of Senator Enrile.
Yes, ma'am.
Isn't it true, Justice, that in writing the decision or in deciding cases, after the statement of facts, we find the law applicable? And in the case of Senator Enrile, the Constitution is applicable. As what you said, every accused is entitled to bail except those charged with capital offense when the evidence of guilt is strong. Well, this incident, the finding whether or not the evidence of guilt is strong has not been shown. Because before the Sandigan Bayan, the motion filed by Attorney Mendoza was a motion to fix bail, claiming there are mitigating circumstances, old age, voluntary surrender. But then the Sandigan Bayan denied the motion for prematurity. It was premature for Attorney Mendoza to file that motion because Enrile was not yet arrested. And then Attorney Mendoza went up immediately to the Supreme Court, claiming that the Sandigan Bayan committed grave abuse of discretion. Justice, do you think the Sandigan Bayan, on the basis of those incidents or facts, committed grave abuse of discretion?
I don't think
in
so.
Denying the motion? Yes, there was no grave abuse of discretion.
I don't think there is a grave abuse of discretion.
And yet the Supreme Court, instead of applying the Constitution, readily granted the bail in favor of Enrile. So if you are a member of that court, would you have dissented or concurred? Tell me.
I would have dissented.
Correct. Anyway, you are very intelligent. You have read landmark decisions of the Supreme Court, applying the theories on your decisions also in the Court of Appeals. Can you enumerate just these 2 or 3 or even 5 decisions of the Supreme Court you consider erroneous?
That one, and I think also the
And Reyes case, number 2,
the midnight appointment case of
Corona.
yes, ma'am.
Why?
Because for me,
Constitution is very clear.
very clear. When you say you cannot do it, you cannot do it.
And the provision states 2 months before the national presidential election and up to the end of his term, the president cannot make
appoint.
any appointment except
in executive in a temporary capacity.
minor appointments
In
when the
executive and in
vacancies
temporary
will
capacity.
cause prejudice to the service
Yes.
or security.
And it's only referring to the executive. It does not refer
That's
to
why
appointments
Justice,
in
when
any
you
other.
go up to the Supreme Court, don't ever deviate from the Constitution.
That is our Bible, ma'am. We
Can
have
only apply equity if there is no law applicable, di ba? Another decision, Justice, you consider erroneous, grossly erroneous.
grocery. I cannot say anything. Those are the only things probably that came into my mind. I have not, reviewed each and every case. Probably if I will be led,
So Senator Enriquez case, Corona's case. How about flip-flopping?
flip-flopping.
Decision was already final, executory, and yet the Supreme Court will reverse itself.
I think that's the FASAP case, the case of the stewardess.
Yes, another one.
It's already final, and then a second motion for reconsideration. It was entertained.
At the end of the day, PAL won.
PAL won.
Else.
I have not.
Have you come across the Dinagat case, province of Dinagat? It was although
the cityhood case.
no Dinagat first. Although the requirements were not complied with, underpopulated,
with
the
respect
capital,
to redistricting,
income,
and population, it has
that is Dinagat. It was converted into a province,
it was already
separating from Surigao.
it was already
You are
final.
referring to the cityhood.
Cityhood. Okay, but
Cityhood.
that case also is final, and then it was done in a reconsideration.
ASAP, Dinagat, city. Erroneous. Tell me more.
Ano po?
Erroneous.
Erroneous.
Siyempre meron.
Meron po.
The Supreme Court is not perfect.
Meron po.
Commits mistakes.
But
So are we.
I hope when I will be there, I would have a chance to correct this, and given my wide perspective on all these things.
The cases of Grace Poe. The
I have
case against GMA when the demurrer to evidence, was granted and she
granted.
was acquitted without her presenting his defense.
Evidence.
What else?
Grace
You will
po,
review the decisions you will find, maybe if you are already there, you could have dissented.
probably.
Grace Poe, what is your comment on Grace Poe? No,
Martial law.
you are now the ponente of that petition filed. Most of the petitioners are lawyers, and the issues are whether or not it was a violation of the Constitution that both houses did not convene, and whether or not there is factual basis for the declaration of martial law, whether or not the Supreme Court can rule on factual basis. Okay, number one issue.
The Supreme Court will rule on the factual
The
basis.
Congress did not convene itself.
They-
Although the President submitted his report within 48 hours. So, if you are now the ponente, how will you decide these issues, Justice?
Because
you are very intelligent lady.
to convene the
Let us
Congress,
see.
it is for the revocation. It's not for the approval. So,
Meaning Congress is mandatory under the Constitution.
Yeah, but it's only for revocation. It's not for approval of the... But probably in
Meaning
the next...
to say,
in the
you
next-
will follow the Constitution. Congress should have convened, right? But it did not.
that Congress should have
To
convened.
determine whether there is factual issue.
Of course, that's part of it because that's part of their power to revoke or even to extend if the president
To extend upon request
of
again
the president. But they have to convene because they have the power. They should.
You are the ponente, you will order Congress now to convene. Yes or no?
Probably I will.
Issue for Congress now to determine whether there is factual basis. And if Congress says there is factual basis, what will be your decision as the ponente?
Since the Congress would determine that there is factual basis, there is no revocation that they will order the president to observe.
Congress will not revoke.
Congress will not revoke the declaration.
Supposing Congress says there is no factual basis, what will be your decision as the ponente?
If there is no factual basis, so the declaration should be set aside.
You will
If
appeal
there is no factual
the
basis,
findings
if
of
there is no factual basis,
Congress. Okay, let's go to the suspension of the privilege of habeas corpus. A while ago, you said that those persons who are already facing charges for rebellion or offenses connected
Related
with invasion should not be released. And during the existence of martial law, those persons committing rebellion or offenses connected or involved in invasion, what will be the action?
because the Constitution is also very restrictive. These people have been arrested without warrant for rebellion and for offenses incident to invasion are supposed to be charged within 3 days. Otherwise, they will be freed. So
About those persons already facing those charges,
they will.
already arrested and in jail.
So the court will determine whether the acts
They will
relate.
remain in jail. They will remain in jail.
Yes, ma'am.
That was the issue or the article of Justice Vic Mendoza in the Inquirer, as against the opinion of Senator Franklin Drilon. Okay. So, how about, what is the other case? Marcos Berial? How about Marcos Berial? Would you have dissented or conquered?
Plainly, on a moral ground, there should no burial that should have been allowed. But there is really no law prohibiting the burial. So, if I were there, I would really seek my further study on the matter. But since it has already been decided that the burial should continue, so it's
The
some
legal basis relied upon by the Supreme Court Justice was the Armed Forces of the Philippines Regulation 365.
It has
Enumerating the people who should be buried there, like the presidents, secretaries of national defense, chief of staff, soldiers. But there are 3 exceptions. Number
those
1,
who were allowed by the president to be buried.
those dishonorably discharged.
The exceptions who can be
Exceptions.
the exception, those who are dishonorably discharged, and then the other one is crimes, persons who
convicted
were
of crimes.
convicted of crimes involving moral turpitude.
And the third,
The third, what is the third? I cannot remember the third.
Marcos falls within those exceptions
He was dishonorably discharged by the People Power
by the
Revolution.
people. And
That is
how
the
about
highest form. He was not. He was not.
Look at those tortures, numerous murders,
What had
etc.
happened is something that there is really no need for an actual conviction because what he has done is widely known. Widely known, internationally known. He looted our treasury. He He brazenly disregarded the rights of the people.
So, Justice, thank you. Good luck. You are excused.
I hope I get your votes. Sir, ma'am, sir. I am done. Thank you, sir. Thank you, ma'am. Shall I give the comment to you, or I'll just... I have provided... because this is the last set of papers that I asked my staff to deliver to the JBC. Maybe it's somewhere else. No, I'll just give the copy of my comment, the copy of the order that we have issued in relation to this, and then the copy of the complaint. That will be submitted to the office this afternoon, sir. Thank you for...
Last to be interviewed for this morning, Your Honor, is Court of Appeals Associate Justice Stephen C. Cruz. Justice Stephen Cruz, Your Honor.
So, good morning, Justice. Please take your seat. And may we request now Judge Ilaw to start.
Thank you, Madam Chair. Good morning, Justice Cruz.
Good morning, Your Honor.
All right, the first question is, how were you admitted to the New York bar without taking any examination? What? Yes, please.
Okay, if you are, please. That was in 1982 when in the New York Supreme Court had a provision that if you are a graduate of a university like UP or Ateneo, they consider
Only UP and Ateneo?
only during that time.
During that time. Not some better. Okay. Please continue.
They considered it as a substantial educational equivalent of a law school in the United States. And if you, excuse me, have practiced for 5 years in your jurisdiction, you can petition the Supreme Court of New York to be admitted without examination. So it's a process. You file your petition in writing, they answer back to you, they give you the requirements, and if you completed it, they will rule on that petition for admission without examination. Usually they do it, rule on it favorably. Then they will schedule you for an interview with the Supreme Court itself, with a justice. And if you pass that interview, it's a face-to-face interview. It's usually done in cases of non-citizens in Albany, New York. After that interview, you will be scheduled right there and then to the next chamber to take the oath as a member of the bar of New York. I had all the qualifications, and that was in 1982. I learned that most Filipinos similar to my situation, also applied. One prominent one was Attorney Joker Arroyo. He also applied and he got admitted. My classmates applied, they got admitted. And then all of a sudden, the Supreme Court of New York notice the flooding of Filipino lawyers applying to be admitted without examination. They closed that provision. As things stand now, you have to take the bar.
So that is the present rule also?
Yes, yes, Your Honor.
So tell me something about yourself which is not found in the personal data sheet.
On anything, Your Honor?
Yes, please.
Well, I love to play golf.
What's your handicap? Your wife? No?
It's Giant Killer 21, Your Honor.
No, wow, galing. Attorney Mejia is also a golfer. And in your PDS, you only cited one training or seminar. How come? But since justices should be abreast with recent legal developments.
Yes, Your Honor. That one was overseas in New York. No, in Harvard, just 2 years ago. But I attend local symposia and conferences initiated by the Judicial Academy or the IBP. It's a long list, but I did not bother to put it there, considering that it's an ongoing thing.
All right, in a scale of 1 to 10, 10 being the highest, how would you rate your performance in the Court of Appeals?
Modesty aside, Your Honor,
Yes.
7 or 8.
Why do you say so?
I keep abreast with the disposition of cases, although I am not a top-notcher in disposition. I keep abreast also on the decisions using the latest jurisprudence on matters before me.
At your age, are you computer proficient?
Yes, Your Honor.
Where did you learn your computer skill?
During my practice of law, before I joined the judiciary, and during
Your computer games? What? Ano?
not computer games.
Sorry.
It's I do decisions straight from the computer, Your Honor.
In your 17 years in the Court of Appeals, what novel reforms did you introduce?
I'm not a sole player, I'm a team player, so I contribute to the zero backlog of the Court of Appeals, headed by our presiding justice, who's really doing his best in the zero disposition, and I think we have achieved that. Also, the computerization on how cases come in on the first day, monitored it along the way until it goes out of the Court of Appeals. There are statistics and subject or classification of cases, be it special cases, habeas corpus cases, criminal cases, heinous crimes. It's classified and well docketed, Your Honor.
What do you consider your greatest and most important contribution to the public service? None?
Your Honor, please,
Public
I'm
service.
part and parcel of the disposition of due process and justice and the general welfare of the Filipino people, especially in the judiciary side.
But what can you offer to the Supreme Court that no one else has offered before?
I have been toying with the idea of what I call the system of limited appeals, so as to decongest the Supreme Court and other courts. Like cases within the jurisdiction of the lower court, like MTC, METCs, can only be appealed twice. Regional trial courts, Court of Appeals. And that becomes final. It cannot be appealed to the Supreme Court except when it is new jurisprudence. It will be beneficial to many, or a new case, exceptional one. But that would be dependent on the Supreme Court's acceptance. It cannot be a matter of right. And the Supreme Court can only accept that appeal if it deems so. And then the two appeal rule before RTCs, Court of Appeals, and then the Supreme Court. That's it. And then with the exceptions that I have mentioned, if it is a new case, never been tried before, it is a precedent-setting case, then subject to acceptance and rejection. Meaning, if you appeal, the court can reject it as to be baseless or not meritorious at all.
What would have been the prohibited pleadings that may be filed? Just for example, Rules 65, the most abused. That's only cases reaching the Supreme Court deal with question of law.
Yes, Your Honor. In fact, the Supreme Court is doing it right now. All cases under 65 can be dismissed via minute resolutions, considering that it's a frivolous case or what. And the Supreme Court can only accept meritorious cases, and then maybe limited really to memoranda. Oral arguments is not the general rule, but rather the exception.
All right, thank you. My time is up. It's already and a warning. Thank you very much, and good luck, Justice.
Thank you, Your Honor.
Thank you, Judge Ilaw. May we request now Attorney Mejia, please.
Thank you, Madam Chair. Good morning.
Good morning, Your Honor.
Justice Cruz. You have been interviewed at least during my term twice, and the last was in January 2016, if I'm not mistaken. Is there any significant development in your career that you would like to share with us since your last application?
Well, I've been doing my stint, to repeat, as a team player in the Court of Appeals. I try to achieve maximum disposition of cases, but to one significant thing would be not violating the subjudicial rule, Your Honor, is to maintain and administer the law in its right perspective. Meaning I'm doing justice where justice is due.
During the recent oath-taking for the new lawyers, Chief Justice Sereno emphasized the need for new lawyers to render services in far-flung provinces by way of legal aid and efficient access to the courts. What measures do you think does the Supreme Court need to implement such objectives?
Well, just like in medicine, or when you become a doctor, you are required to do rural services. Maybe for the first few years of your admission to the bar. And that can be monitored through the IBPs of the local provinces or cities, that you have done rural services in your place of choice. Then from there, you proceed to practice on your own or your choice of specialty. But first things first, Your Honor, you must do, for lack of anything to describe it, rural service.
Has there been any instance, I am now reading a tweeted question, has there been any instance when your religious beliefs conflicted with your interpretation of the law?
I don't think so, Your Honor. I just apply the law. As the saying goes, Your Honor, let justice be done, though the heavens fall.
Also ask your opinion, as I had earlier propounded, your views on the martial law, the Enrile bail, and the Marcos burial. Very briefly for each issue, Justice Cruz.
Martial law, can I clarify martial law?
The martial law declaration, your view on the validity of the martial law declaration.
Well,
Yeah, the current one.
the threshold was there sufficiency of material facts at the time of declaration? Is that limited to that? Or can you consider activities or developments after the declaration so as to give more teeth to the basis of the declaration, like what's happening now in Marawi? It has become a full-blown thing. I would view it that the facts should be limited to the time of the declaration, and the subsequent facts would validate that declaration. Because if it does not, let's say the subsequent facts would say there is no really an armed conflict in Marawi, then the basis of the declaration would not be there. So in effect, I would subscribe to the idea that the facts surrounding the declaration itself to be validated by the supervening facts, whether it is right or wrong.
For my final question, how will you, I'm sorry, there are other two issues po pala that are,
What's the other one? May I?
the Enrile bill,
Enrile bill.
bail, the granting of bail to
Oh.
Senator Enrile.
Well, it's discretionary really to the court granting it. Facts, as I've said, are not stagnant. It's ongoing. And if the facts would support the conclusion of granting bail, be it subsequent, before, or after the detention, and really should be granted bail, Your Honor. And as the Supreme Court would reckon it considered some supervening facts also.
What about the Marcos burial po?
Marcos burial. It's really how you look at it. I mean, how the libigan ng mga bayani is, how does it exist? Is it really for the heroes? I have read in one paper that even a dog was buried there. So would the end justify the means? I mean, if it's really for heroes, next question, was Marcos a hero or a heel? That should be determined. I guess there should be hearing for that purpose. And what was happening now is really an ongoing event again that could aid the Supreme Court in deciding it. But for myself, since it's not really a strict cemetery o libingan for ng mga bayani, and since a pet or a dog has been allowed there, the possibility of Marcos being buried there is a possibility, Your Honor.
Thank you. And finally, how will you maintain your independence and keep your independence should you be appointed to the Supreme Court?
This is twofold. One, you have to be a team player with other justices. But then again, you have to be independent in deciding cases. But really, what you firmly believe is the right decision. So the two must coexist. There's a barrier between being a team player and another barrier for having an independent decision or independent mind in drafting a decision.
Thank you, and good luck again, Justice Cruz. Thank you, Madam Chair.
Thank you, Your Honor.
Thank you so much, Attorney Mejia. Good morning again, Justice.
Good morning, Your Honor.
You see, of course, you understand that one of the rules of the JBC in determining the qualifications of candidates or applicants is to test their mastery of laws, rules, and jurisprudence. Okay, this is a follow-up question to the questions propounded by Judge Ilaw. What subjects did you take up when you studied at Harvard?
It's negotiation.
Business?
It's arbitration and negotiation.
Did not study any decision rendered by the U.S. Supreme Court?
No, Your Honor. It's art of negotiating.
Universal Declaration of Human Rights. Justice, can you cite at least 5 acts being protected by this Universal Declaration of Human Rights?
5 what, Your Honor?
Universal Declaration of Human Rights adopted by the UN General Assembly on December 10, 1948. Human rights, protection of human rights. Can you cite at least 5 acts being protected by this Universal Declaration?
Well, one is right to life, liberty, and property. One is right to...
Right to life, liberty, and security.
Yes. Right to express yourself, or freedom of the press. Right to live, or...
The right not to be engaged in servitude or slavery.
Yes, slavery, Your Honor.
Again. Right to have a nationality.
Yes, Your Honor.
Right to be recognized as a human being anywhere in the world.
Yes, Your Honor. The
right to equal protection. And so many of them, Justice, I hope you will go over this declaration before you go up to the Supreme Court, just in case you are lucky to be nominated and appointed.
Yes,
okay. You are one of the 3 justices mentioned by Secretary Alvarez, who issued the writ of habeas corpus
Yes, Your Honor.
to the 6 provincial officials of Ilocos Norte.
Yes, Your Honor.
I'm not reviewing your action. I just want to find the legality. Okay. So why did you issue the writ, Justice?
A petition was filed.
No. Let's make this very clear and short. These 6 officials refused to answer the questions of the congressman investigating them. And that was the reason why they were cited or punished in contempt of court. That was the reason why they are being detained. Okay. What was your legal basis in issuing the writ of habeas corpus?
Well, as the writ of habeas corpus is defined under our rules, Your Honor.
Persons illegally detained.
Yes. No, Your Honor, please.
Do you think they are illegally detained?
That's the point, Your Honor. They are detained, and the habeas corpus proceedings.
No, they are detained. Are they illegally detained?
Precisely, Your Honor. That's what we were finding out. But we were not given a chance to see the legality or illegality of the detention. Because
But why
those,
did you issue the writ when you did
to
not find the
determine,
legality or
yes, Your Honor,
illegality?
to determine really if the detention was legal. That's it. I mean, we want the bodies to be presented before the court together with the person who is detaining them and determine whether it is legal. Because if it is legal, we will dismiss the petition.
But you ordered the release. Therefore, you found that the detention is illegal.
No,
You
Your Honor.
are ordering the release.
If Your Honor, please, that was pursuant to a case in Reyes versus Salazar, wherein persons subject of a writ of habeas corpus, while the merits are being determined, can be released on bail. Enrile versus
But you are
Jaime
just saying
Salazar.
a while ago that there should be first a determination whether or not
Yes, Your
the
Honor,
detention is
we're
legal or
doing that,
illegal.
but-
The question is, why did you release if that is your
Because
theory?
there is a motion filed, and we required the respondent to comment. After receiving the two, we determined that under Ponce Enrile versus Salazar, they have the right to bail, while the habeas corpus,
What was the comment?
again, they are raising the issue of jurisdiction. They say that the Court of Appeals has no jurisdiction over proceedings by a House committee in aid of legislature.
According to Speaker Alvarez, the three of you should be impeached. And in fact, right now, 120 congressmen have signed a petition for disbarment. Your comment, please.
What we did, Your Honor, was our duty. We found that the writ should be issued. Again, if we falter because of some threats, that would show our weakness as a magistrate. And as I have said a while ago, let justice be done though the heavens fall. I mean, if we are wrong, they could always go up to the Supreme Court.
Your first answer should be, justices of the Court of Appeals are not impeachable.
I know, Your Honor,
Oh, that
they-
should be your answer. But there is a petition for disbarment. Your comment on this, Justice?
Well, we will face that matter, Your Honor, when it comes, and we welcome it. So the truth will come out.
Do you think your act was in violation of the principle of separation of powers?
Well, under the principle of checks and balance, Your Honor, the Supreme Court or the courts can inquire, like in a habeas corpus case, inquire whether the detained person are being detained legally. Because if the detention is legal, we will dismiss the petition for being unmeritorious because the detention is legal. But if the detention is illegal, by looking into it, like what was done in Arnold versus Nazareno, wherein the Supreme Court ruled that the witness refused to answer Arnold, although he knew the answers, but he refused to answer, had a criminal mind. Therefore, rightfully, the Senate cited him in contempt until he answers. But we didn't have a chance to do that because right on day one, respondent, the Sergeant at Arms, may I stress, Your Honor, the respondent here is only the Sergeant at Arms, not the Speaker. Refused. For some reason that he asked for a consulta with the Speaker, and the Speaker wrote a letter to us raising the issue of jurisdiction. So we deemed it proper to initially rule on the issue of jurisdiction. And considering this is a habeas corpus case, wherein the detention of the persons involved and the legality of it should be looked into, the Court of Appeals has jurisdiction.
Is not the Court of Appeals interfering with the procedure or processes being undertaken by Congress?
If Your Honor please, reading Arnault versus Nazareno, the Supreme Court looked into the proceedings by examining the transcript of stenographic notes, whether the witness who refused to answer was in good faith or had a criminal mind. Up to the extent, because that can show whether the court can proceed and release the persons under habeas corpus or dismiss it.
Okay, Justice, what is the basic difference between a writ of habeas corpus and a writ of amparo?
Writ of amparo is really related to the data. It can cover persons not detained. A writ of habeas corpus only covers persons detained.
And the basic difference is writ of amparo protects the security of all persons.
Yes.
In fact, all our rights under the Bill of Rights are being protected by the writ of amparo.
Precisely, Your Honor.
Whereas
The
habeas corpus only protects the liberty
Yes, Your
of a
Honor,
person.
and that's what we're doing. We're just looking into the legality of the detention.
Anyway, Attorney Mejia mentioned the Marcos burial.
Yes, Your Honor.
If you are a member of the Supreme Court, would you have dissented or concurred?
I would have, personal opinion, Your Honor, I would have concurred.
Why?
Because really, as explained, the libingan of the bayani is a misnomer. It's not restrictive to heroes.
Who are entitled to be entered there? Can you enumerate? Read the decision of the Supreme Court written by Justice Peralta? Just say yes or no.
I looked into it, but I did not read it.
You did not read it.
Yes.
That's why you won't be able to answer my question.
Yes, Your
What
Honor.
was the legal basis of the Supreme Court in authorizing or allowing the burial of Marcos there? I advise you, Justice, to read that decision. Very interesting. You could have dissented.
Yes, Your Honor.
How about the case of Enrile? The granting of bail.
As I've said, Your
You
Honor,
are
I am
concurring?
Yes, Your Honor, please.
Why?
Because of subsequent events. I mean, the man is an old senior citizen, about 80s. I mean, he could have
What is the constitutional provision on the granting of bail, Justice? You know this very well.
Humanitarian purpose, Your Honor.
The Constitution.
Well, a bail is a matter of right unless...
All accused are entitled to bail,
Yes, Your Honor.
except those charged with capital offense when the
And that will
evidence
be
of guilt is strong. Okay.
Discretionary only.
Was there a hearing conducted by the Sandigan Bayan to determine whether or not the evidence against him was strong?
I am not aware of that, Your Honor. I didn't.
There was no hearing.
I'm not aware.
Before you write your decision, di ba, Justice, you first relied on the available laws or jurisprudence.
Yes,
The
Your Honor.
Constitution was available for the Supreme Court. It is very clear. And even jurisprudence. So before we rely on equity, such as humanitarian reasons, di ba ho, we should rely first on the Constitution or law.
Yes,
So
Your
do you still concur or dissent?
Well, in the absence of law,
That
equity,
the Constitution and the rules. Please read the decision again, Justice. Oh, thank
I
you
will
and
do
good
that,
luck.
Your Honor. Thank you, Your Honor.
That's all for this morning, Your Honors.
The session is adjourned to be to be called again this afternoon at 2 o'clock.